Hey everybody, welcome back. It's good to see you again, except I can't see you. But I hope you can see the PowerPoints, and the chat box is open, so if you have any questions or comments, feel free to drop me a line in the chat box. And today we shall be reviewing and completing the duty of care, and then getting on to breach of the duty of care. Okay, so a quick run through what we covered last time. I'll just focus on the important points. So this is by way of revision. Remember the elements of negligence. Obviously, there must be a duty of care owed, O-W-E-D, by the defendant to the plaintiff, and that's what we're focusing on right at the moment. Then we're going to get on to the second element of negligence, breach of the duty of care. And we should finish off breach today, may even get on to causation, which is the third element of negligence. And of course, there must be damage which has been caused. Okay, the damage can either be property damage or personal injury or even death. But also it could be, the personal injury could consist of nervous shock. And then you can also have damage in the form of pure economic loss. Okay, and it's important when you're dealing with issues, dealing with negligence, particularly duty of care, focus on the type of damage that has been suffered by the plaintiff, because that will determine whether duty of care is a big issue or not. Obviously, there must be duty of care owed, but as we saw last time and we'll review in a moment, if the damage is directly caused personal injury or property damage, you don't need to go into much analysis. You just cite Donoghue and Stevenson, reasonable foreseeability, hence duty of care is owed. Okay. Can you cite a case for the elements of negligence? Well, I've got an English case on the screen, which you probably should know. Also, there's a useful Hong Kong case called Cheng and Wu, which dealt with a driving case. So if you want to cite a case on the elements of negligence, then, well, you can cite probably Cheng and Wu is a good one. So do we have any Chengs in our... Oh, we do! Cheng Hong Man? Well, yeah, there's your case. And any Wus? Wus. No, oh, we got a W-U, but not W-O-O. Okay, so... you don't really need to cite a case for the elements of negligence, okay, but if you want to, that's one you could do. Okay, now remember, when it comes to duty of care, it's before Donoghue and Stevenson and after Donoghue and Stevenson. Such an important case. You know the facts, so next time you have a drink, be careful. I've got my bottle of water here. I can see through it. No decomposing snail. Remember, Mrs. Donoghue's friend bought the bottle, but she then bought and drank the ginger beer bottle. She couldn't see what was inside. There was a decomposing snail, and she suffered nervous shock and got gastroenteritis. Could she sue in contract? No, no privity of contract. Could she sue in tort? Well, at that time, no, but then the law changed. The House of Lords, notably Lord Atkin, did say that there could be a duty of care owed if you can prove those two elements of reasonable foreseeability and proximity. Proximity comes from the neighbour principle, okay? Remember, the duty of care is a kind of relationship between the tortfeasor and the victim, the plaintiff and the defendant. Recognise the court as being giving rise to negligent liability. So the defendant will only owes a duty of care to a person who's, if you like, close enough to him. And of course, that's another way of saying proximity. So who is your neighbour? A person who's so closely, the important word is closely and directly affected by my act that I ought reasonably to have them in contemplation as being affected by my act. Of course, what do you mean by reasonably foreseeable? Again, it's a vague term. Predictable, I suppose you could say. But the courts are always a bit hesitant to come up with a black and white definition of these terms. They are all vague elements when it comes to deciding whether a duty of care is owed after Donoghue and Stevenson. So the court can consider one or more of these elements, and then they will decide whether there's a duty of care. Of course, they'll be bound by the laws of precedence. Okay, so these are vague definitions, and there is considerable overlap between them. With regard to reasonable foreseeability, how wide is it? Well, the Dorset yacht case is a good one. Okay, the facts are pretty clear. You got the Borstal boys on an island. They want to escape from the island, and so it's obviously they want to steal a boat, and the Dorset Yacht Club was quite close, so there was proximity in the Dorset yacht case. So reasonably foreseeable that the boys would want to escape from the island, reasonably foreseeable they could steal a boat, and the Dorset Yacht Company was proximate. Okay, so duty of care was held to exist in the Home Office and Dorset Yacht case. Annes and Merton, the court seemed to go too far there because the type of loss in Annes and Merton wasn't directly caused property damage, it was just pure economic loss. It was just the risk of the building collapsing, it hadn't actually collapsed yet. So everybody, well, certainly later House of Lords case such as Murphy says that Annes went too far. So Annes has been disapproved. Yun Kang Lu is also a good case in which the court said there's no duty of care on the Commissioner for Deposit Taking Companies. Again, you could argue no proximity. Also, you could argue policy reasons because the Commissioner of Deposit Taking Companies is a public authority. Okay, and generally the law doesn't want to sort of impinge on public authorities, if you like. So with regard to the development of the duty of care after Donoghue and Stevenson, well, Caparo is a good case. It says, well, the courts will only extend the situations in which a duty of care is owed, in which, in a step-by-step process. Oh, you can't see the PowerPoint. Oh, okay, just a minute. I'll see if I can get some help to sort out the PowerPoint sharing. We'll have a short break to do that. Okay, everybody, I think we're okay now. I'm operating two screens. What happened is I was sharing the wrong screen. Now you should see all the PowerPoints. Okay, oh, well done. Back into business, isn't it? Marvellous. Okay, well, if you have a little problem, sort it out. Well, okay, I'll quickly run through the PowerPoints I did before. I mean, this is all revision, everybody. Make sure you know the elements of negligence. Okay, so we're focusing on breach, and then we're going to get on to duty tonight. Remember, duty of care is either before Donoghue and Stevenson or after Donoghue and Stevenson. After Donoghue and Stevenson, we've got these two elements of reasonable foreseeability and proximity. Okay, so these are the elements, and yes, must know these elements, but appreciate they are vague and they overlap. And you really just have to look at each particular case to see how the courts have applied these elements. And it can get a bit confusing. So this is why, as I say, when it comes to duty of care, everybody, focus on the damage suffered by the plaintiff. That will tell you how much you need to go into in analysing the existence of duty of care. And directly cause personal injury or property damage, you only need to show reasonable foreseeability, and you can simply cite Donoghue and Stevenson. So in examination questions, that's all you would need to do on duty of care, full stop. However, if the damage suffered by the plaintiff is either nervous shock or pure economic loss, you do need to go into further analysis. Typically, you also have to show the element of proximity. Okay, and then Dorset Yacht is a good application of Donoghue and Stevenson. Annes and Merton, the court went too far because they found a duty of care was owed when the loss was only pure economic loss. And so they should have shown had to prove the extra element of proximity, but they didn't do it. Okay, Caparo is a good case. Yes, I'd say Caparo should know, bordering on must know. So Donoghue and Stevenson, must know case, good. Caparo should know, bordering on must know, in that Caparo says the courts will only extend the situation where duty of care is owed in, small increments, the step-by-step approach. So are they two separate elements, reasonable foreseeability and proximity? Certainly in Dorset Yacht, the courts treated them differently. So Dorset Yacht's a good case. I think Dorset Yacht's definitely should know, but probably not must know, but it's a good application of Donoghue and Stevenson, in which the court said, we will apply Donoghue and Stevenson unless there's a good reason not to apply it. That covers pretty well everything, isn't it? Anyway. And then, of course, the court comes up with these other elements: fair, just and reasonable, very, very vague. Do we really need this criterion? And remember, the court said in the Mark Rich and Alcatel cases that the plaintiff can sue for breach of contract, so we don't need to find a duty of care. And they stretched it a little bit by saying that the type of loss suffered in these cases was not directly caused physical damage, it was indirectly caused physical damage. And everybody asked that query at the bottom, hang on, wasn't this direct? So it's the court saying, we don't think a duty of care should be owed here, so how are we going to justify it? Oh, we'll say it's not fair, just or reasonable. So, that's the way the courts work. And then, of course, policy will restrict the application of a duty of care. And particularly when the defendant is a public authority. I've got these cases of Stoven, Wise, and on the screen. They were public authorities, and the court found no duty of care was owed in those cases. However, it is possible a duty of care could be held in some cases involving a public authority, but it would be very, very, very rare. Okay, and Yun Kanyu is an example of the courts applying policy to rule out a duty of care owed by the Commissioner of Deposit-Taking Companies to investors. Okay, and then with regard to policy, the leading case is the Hill case. And remember, in this case, the court said no duty of care for practical reasons, really. Well, number one, of course, the defendant is a public authority, the police. And if you impose a duty of care on the police, they'll be too scared to do anything. And it may lead to the exercise of a function being carried out in a detrimentally defensive frame of mind. And so that's not good. We want the police to be proactive, not sort of sitting back, cowering in fear in their police stations, worried about having to be sued for negligence. And so that was approved more recently in the Brooks case, but then in the Smith case, the court did find there was no duty of care, but the elements of proximity, if you like, were very, very compelling. And the court said, well, there may be situations which the police do owe a duty of care, but we're not going to find it. We're not going to change the law. If there's going to be a change of the law in this area, it should be by way of legislation. Okay. With regard to lawyers are now more liable than we used to be, particularly solicitors. Solicitors owe a duty of care to beneficiaries of a will. They didn't owe it before. Okay, you obviously owe a duty of care to a testator who makes the will. But now, after these cases of Ross and Corters, White and Jones, duty of care is owed to beneficiaries of a will. Okay, and Trend Publishing, don't worry about Trend Publishing, I just threw that one in because I like Mr. Justice Keith. Okay, rescue services, will they, are they immune from being sued for negligence? And the court said, well, usually they will not be owed a duty of care, but we will treat them like the police, unless, of course, there is some compelling reason to impose a duty of care. So really, it's up to the courts. The courts, when it comes to duty of care, have a great deal of discretion. And Caparo, though, says that the courts will only extend the situations in which a duty of care is owed step by step, an incremental approach. And they say, well, you've got to show reasonable foreseeability, usually also have to be sufficient proximity, and then a duty of care will only be imposed if it's fair, just, and reasonable to impose a duty. Okay, all right. And then moving on to, oh, that's Caparo again. And I think that's pretty well it for our first lot. But here's our very good summary of duty of care in general. So, is duty of care an issue? Well, in exam questions, everybody, if you are dealing with issues of negligence, always tell the examiner you know the elements of negligence. A duty of care owed by the defendant to the plaintiff, and then breach of the duty of care causing damage which is not too remote. That's your must-know definition. Okay, good. So, is duty of care an issue? Well, if it's directly caused physical damage, or namely personal injury or property damage, then all you need to show is reasonable foreseeability. Donahue and Stevenson says a duty of care will be owed. Okay, so watch out for that in traffic accident situations, because normally the damage suffered by the plaintiff will be personal injury and or perhaps property damage, and so a duty of care will be imposed pretty well automatically. When it comes to car drivers, they owe a duty of care to all other road users, including pedestrians. Okay, so duty of care is not a big issue in traffic accident cases. You tell the examiner you know about Donahue and Stevenson, and that's it. You don't need to go into any other detail. However, if the type of damage suffered by the plaintiff is other than directly caused personal injury or property damage, then you do need to go further. And with nervous shock, unless you're a primary victim, you need to show the extra element of proximity, okay, which we're going to go through in a moment. Pure economic loss, same thing. There must be this extra element of proximity, and there are various ways of describing this need for proximity, a need for a special relationship of proximity, equivalent to contract. That's what some of the cases say. And of course, there is an overlap here with regard to negligent misstatement. So negligent misstatement is also a misrepresentation usually, but in practice you would sue in contract law for misrepresentation rather than negligent misstatement, because it might be difficult to prove sufficient proximity. Okay. So Hedley, Byrne and Heller is the one. In Hedley, Byrne and Heller, we'll look at in a moment, because we're going to review those, the PowerPoints in the other set of PowerPoints in a moment. In Hedley, Byrne and Heller, there was a disclaimer, though, which the court said worked, so there was no liability in Hedley, Byrne and Heller. But Hedley, Byrne and Heller, that disclaimer nowadays would be treated as an exemption clause and would not, and so you can see a very close overlap between tort law and contract law. So if Hedley, Byrne and Heller were to be decided today after the legislation controlling exemption clauses comes into effect, then that disclaimer in Hedley, Byrne and Heller probably would not work. Okay, so the law changed in England in 1977 when they brought in legislation in the form of the Unfair Contract Terms Act, and Hong Kong followed it in 1990 with the Control of Exemption Clauses Ordinance. Okay. Now, with regard to pure economic loss, the principles laid down in Hedley, Byrne and Heller can apply where it's not negligent misstatement, but it could be where the pure economic loss is caused by negligent conduct, not just words. Okay, so this refers to, you know, defective products, defective buildings. And so for a duty of care to be owed, when there's pure economic loss, is still, you do still need to know this, this extra element of proximity. Okay, so let's have a look at those PowerPoints on nervous shock and pure economic loss. So let me see if I can get it. Where are you? Here you are. Ta-da, should be this one. No, not one. No, come back. It should be this one. Oh, here you are. Gotcha. Okay. All right. Well, look at that. Seamlessly changing my PowerPoints. Aren't I good? I always have nightmares about my PowerPoints being seen or not being seen. I've got two screens tonight. I'm in room 301. Lovely room. Some of the rooms I only have one screen, so it gets a bit tricky. This is two screens, so I think probably is better for you at home with regard to sharing the screen. You can see the whole PowerPoint. All right, so very quick run through. Well, sort of repeating ourselves a little bit, but always good. One of my good friends who got me into law, Mr. Justice Kaplan, I said to him, how do I improve my study of the law? Well, he said, what you do is you go through it once. Okay, good, well done. What do you do after that? You go through it again. Okay, good. Is that, well, then you go through it a third time. Each time you go through it, your knowledge gets deeper and deeper. Okay, anyway, so here we go. Obviously, duty of care, we know what it is, a relationship or connection between the defendant and the plaintiff that justifies imposition of legal responsibility for a failure to take reasonable care. So there's got to be a certain degree of closeness, nearness, okay? And obviously the general principle of foreseeability and proximity comes from Donahue and Stevenson. The proximity point is the neighbour. So who is my neighbour? Well, remember that famous quotation from Lord Acton in Donahue and Stevenson, a person who is so closely and directly affected by my act, so closely and directly affected by my act, that I ought reasonably have them in contemplation as being so affected by my act when I'm directing my mind to the acts or omissions which are called in question. I mean, you don't need to remember all of that quote, but it's a very famous passage, Donahue and Stevenson. And of course, proximity is now confirmed as an additional requirement in those cases, Dorset Yacht, Yoon, and the Hill case as well. Hill, you could argue, with regard to the police case, there was not sufficient proximity. Okay, but Hill case, there was no duty of care, mainly because it was the defendant was a public body, the police. So remember, more than one element might be relevant to any particular case. And then, of course, fairness, justice, and reasonableness. I mean, everybody says, why do we have this? It's so vague. Well, it's just another excuse, if you like, for the courts to rule that there is no duty of care owed. Okay, and then, of course, the policy arguments based largely on who the defendant is. Policy, Hill, and we go through the Hill case again. It's a further reason for no duty And of course, again, we've been through this. Public policy requires that when conducting the investigation of crimes, the police be free of worries about being sued. Okay, yes. Okay. But is this unmitigated freedom? Good question. And such worries will cause them to be distracted. And if duty owed, police resources will be diverted to defending tort actions. Is that justified? Okay, well, therefore, not in public interest to impose a duty. However, if, there could be a case in which, you could have a serial killer on which the police know who the killer is. And, if somebody gets killed and the police, should have stopped him, it's possible a duty of care could be owed. But again, the courts are reluctant to impose a duty of care. If the law changes, it'll probably be in the form of legislation. Okay. All right. Good. And then, I'm getting my mouse ready. So there you are, there are all the factors, just to remind you. So what I've tried to do with this PowerPoint is try to sort of tack cases onto the various elements. Again, this is not an exact science, but obviously reasonable foreseeability of harm comes directly from Donoghue. Proximity, you could also argue, comes from Donoghue, but also Dorset Yacht. Remember, proximity was a factor. In the Yuen Kun Yu and Hill cases, the result was that there was no duty of care. So that's why I've got Dorset Yacht contrast Yuen Kun Yu and Hill. So duty of care owed in Dorset Yacht, but not in the other two cases. Justice and reasonableness, there's two cases on that, are Mark Rich and Alcatel, but again, you could argue that the loss suffered by the plaintiff was indeed directly caused physical damage, but the court said we don't think a duty of care should be imposed, so how can we sort of justify it? Well, we'll say it's not just or reasonable because the plaintiff could sue for breach of contract. And then the policy reasons, of course, Hill is your leading case there because, the facts of Hill are quite dramatic, okay? Do we have a serial killer in Hong Kong? I don't know, hope not. So which factors apply? Good question. Not all factors apply in every case. Look to see what type of damage has been caused to the plaintiff. As I say, if it's directly caused personal injury or property damage, it's just reasonable foreseeability, full stop, that's it. Okay. But with nervous shock or pure economic loss, you do need to go further. Okay, so directly caused physical damage, that will be simply reasonable foreseeability. Okay, and you don't really need to show proximity with regard to directly caused physical damage because it's directly caused. Obviously, it's close enough. Okay. Indirectly caused physical damage, this is the rather dubious distinction the courts made, particularly in the Mark Rich and Alcatel cases. Okay. And then if it is indirectly caused physical damage, you've got to show reasonable foreseeability, proximity, and maybe there may other factors. Again, don't worry about this particular PowerPoint, don't worry about everybody. It's just the courts wrestling with this idea. All right, Donoghue and Stevenson has opened up the floodgates. How far will we open them up? Well, perhaps we shouldn't open them up too far. Okay, so this is just the courts wrestling with how far should we go with regard to the duty of care. All right, now getting on to psychiatric injury or nervous shock. Remember we covered this last time. Let's go through the must-know cases in this area because this is a very common examination question. You could get another Part A or Part B of the exam. If it's Part B of the exam, it's the full 40-mark question. So make sure you're up to here. Do I need to write down the year of... Oh, good question. Yeah, I'll answer that. Chan Shung has asked, is the year relevant? Well, when we go through the revision lectures, which I'm not sure when they are, later on this year, I will go through examination technique. And one of the questions will be, do you need to remember case names? And the answer is yes. Do you need to remember all of the case name? Well, if you can, but If you can't, one of the names will do. Do you need to remember the level of the court? The answer is yes, particularly if it's a leading case, and particularly if it's a high-level court. So Donoghue and Stevenson, House of Lords, good. Do you need to remember the judge who gave the leading judgment? I would say yes, you could get extra marks for that, Lord Atkin, okay. Do you need to remember the year in which the case was decided? In my book, no. Now, other teachers might disagree with me, but let me justify why you don't need to put the year in when you write down a case. The answer is pretty simple when you think about it. You might have a case that's decided in, I don't know, 1970, but not reported till 1973. So what year do you put in? Good question. Okay. So in my book, year is not necessary when it comes to citing cases. Of course, the year is important in practice in that you need to get a feel for when was this case decided, okay, because the law does change over time, but you don't need to put the year in a case, certainly in any examination I mark or in your assignment, okay, so I hope that's clear. Case names, yes, both names should know. If you can't remember both names, one will do. What happens if you can't remember any of the names? This sometimes happens. You could put down in a decided case. Yes. Don't overdo it, okay? I have marked exam papers in which the student didn't actually cite any names. They just said in a decided case, and they did it about 20 times. Really annoying. They may have even passed, but lost a lot of marks. Okay, case names are important. Your sources of law, case law and legislation. Case names are definitely important because they're your sources of law. Okay, so certainly the must-know cases, you should know, well, must know the name of the case. Don't need to know which year it was decided, okay, as far as exam purposes are concerned. Okay, so let's go through the must-know cases. The nervous shock, okay. Now, first of all, what is nervous shock? Must know Hinsonberry, perhaps Wong and To. Good to have a Hong Kong case there. So Hinsonberry, I'd say must know. Wong and To should know. Okay, so they say it has to be a medically diagnosable psychiatric injury. The fact that you're worried or distressed or annoyed at something or slightly depressed because it's Monday isn't sufficient. And it has to be shock-induced. Something suddenly, oh gosh, that would be nervous shock. So typically some sort of accident, okay? All right. So just elaborating on Hinsonberry, stroke Wong and To, mere depression, distress is not sufficient. So don't worry, you can't sue for nervous shock because you're preparing for an examination, not sufficient. And it must be shock-induced, sudden, means that the psychiatric injury suffered over an extended period. Well, you know, looking after somebody who's chronically ill or injured, that would not be sufficient to grant a claim for nervous shock or not to prove nervous shock. Okay, so that is what nervous shock is, must know Hinsonberry. And also I'd say Wong and To, which says the same thing. So everybody, with regard to nervous shock, the second must-know case is Page and Smith. Second must-know case, draw up your list of must-know cases. It is House of Lords, so that's worth noting. You don't need to worry about the year, but it's fairly recent, 1996. So if you are a primary victim, well, who is a primary victim? One who's actually physically injured and also suffers nervous shock, or somebody who's not physically injured but is in the line of impact. You're in fear of your own safety and you suffer nervous shock, you are a primary victim. So all you need to show for a duty of care to be owed to you is reasonable foreseeability. Full stop, that's it. Okay, Page and Smith is your must-know case. All right, but make sure you know clearly the distinction between primary victim and secondary victim. Okay, good. So there you are. That's two must-know cases. Oh, well, perhaps three. Then we get on to, now I've amended this PowerPoint slightly because of a question from one of you last time, which is a good question. So this is background, this is history. The first three cases, everybody, are history, so background. So they only should know. The must-know case on secondary victims is Alcott, which we're going to look at in a moment. The question I asked with the first three cases, indeed Alcott, can a secondary victim, is a secondary victim owed a duty of care? Okay, well, DeLue and White in 1901 says no, secondary victims cannot claim for nervous shock, full stop. Okay, and DeLue and White says only primary victims are owed a duty of care in nervous shock. So, I mean, that's a long time ago, 1901, so the law was a bit tough because medical science didn't really recognise mental illness as much as they do today. Okay, so DeLue and White on page 72, history, they were pretty tough. Okay, and in DeLue and White, DeLue and White, where was it? Their pregnant barmaid suffered nervous shock when a carriage came off the road and crashed into the bar where she was working. She subsequently miscarried due to the shock. Okay, and he says you can only claim if you are a primary victim. Can't claim if you are a secondary victim. However, Hambrook and Stokes, 25 years or so later, said yes, secondary victims can claim a duty of care for nervous shock. Hambrook and Stokes, secondary victim, the court, and on the facts, the court found that there was sufficient, but you have to prove proximity. And in Hambrook and Stokes, with regard to secondary victims, which we'll see when we deal with Alcott, a secondary victim has to show reasonable foreseeability plus proximity. So in DeLue and White, a secondary victim couldn't claim at all, even if there was proximity. Hambrook and Stokes, a secondary victim can claim, but you've got to prove proximity. And in Hambrook and Stokes, the lady concerned was able to prove sufficient proximity of relationship and the other elements of proximity, time and space, okay, and perception. So in Hambrook and Stokes, the court did find that there was a duty of care. Borehill and Young, House of Lords, a little bit later, said yes, a secondary victim can still claim, make a claim for a duty of care if they suffer nervous shock, but again, you've got to show proximity. And unfortunately, in Borehill and Young, the plaintiff concerned was not able to show proximity of relationship nor proximity of time and space. And so no duty of care owed in Borehill and Young. Okay? So, I mean, interesting cases. This is just tracing the development of the law with regard to secondary victims. So who is a secondary victim? Somebody who suffers nervous shock but is not in the line of impact. Okay, he's not a primary victim, he's only a secondary victim. Okay, and then, so a secondary victims have to show this extra element of proximity, and Alcock is your must-know case on this. Alcock says that the secondary victim has to prove proximity, and proximity of all of the three factors: relationship, time and space, and perception. Okay, and of course, with regard to relationship, proximity of relationship, where are we coming to? If you're in a relationship of parent-child, spouse, that's presumed proximity. Okay, good. I mean, fair enough. I mean, parents and children should be close. Spouses should be close. Okay. However, if you're in any other relationship, you've got to prove close ties of love and affection. Okay. And how do you do that? Well, you would have to produce evidence of close ties of love and affection. I used to mention love letters, but they're a bit outdated. When's the last time you wrote a love letter? Well, you could prove screenshots of your text messages. Oh dear, I missed you awfully. Okay, I'm looking forward to seeing you again. And then 6 hearts or something, and then what else? Cards. I mean, do people send cards these days? I don't know. So you'd have to produce evidence of close ties of love and affection. And in the Alcott case itself, it was a brother who was claiming he was owed a duty of care because he suffered a nervous shock. And the court said, bad luck, no proximity of relationship, because you had to prove close ties of love and affection and you were not able to do it. Okay, so there you are. I suppose these days you can use photographs. Also, the second factor with regard to proximity for secondary victims, you must show proximity of time and space. And the leading case in this area is McLaughlin and O'Brien. Remember, the wife came to the hospital in the immediate aftermath meaning about 1 hour after the accident. So she saw the effects of the accident, the fact that one child had died and there were other relatives, including a husband and other children, had suffered very serious injuries. So she suffered nervous shock. Was that sufficient proximity of time and space? And the court said, yes, it was, because it's almost as if she was at the scene itself 1 hour after the crash. Okay, so, blood everywhere, moaning and groaning and all the rest. So the court said sufficient proximity of time and space. Obviously, McLaughlin and O'Brien also sufficient proximity of relationship and perception, because she witnessed all the gory details for herself. Okay, and then Chung and Lam, the Hong Kong case, goes the other way, and Chung and Lam is a little bit further down your notes on page 78, but in Chung and Lam, plaintiff was the wife of the deceased who was killed in an accident for which the defendant was liable. The mother of the deceased claimed to suffer nervous shock caused by the death of her child after she was told of the accident. And the mother, who used to take care of the plaintiff's child, was no longer able to do so because of her mental illness. But was there sufficient proximity of time and space in Chung and Lam? The court said no, because she only found out, or if you like, she lacked sufficient proximity in time and space to the actual accident, because she only found out about it, quote, sometime later, unquote. Not sure exactly how long that was, but it was more than 1 hour, that's for sure. So where do you draw the line? Is it 1 hour, 2 hours, 3 hours? Well, it will depend on the facts of each case. And of course, if you are if you are asserting that you are owed a duty of care, you would have to prove it. Okay. So if I were, it sounds a bit gory, but take photographs. Photographs are good. I mean, everybody's got a smartphone pretty well, and the cameras are really good. Okay, even somebody as stupid as me can take really good shots. I mean, the good thing about them, you can always blow them up. You can get all these little details from the smartphones. Lovely, they can do so many things. They can act as a torch in the darkness. Oh my, and everything else. Okay, so use your imagination, everybody, when it comes to evidence that you might produce in a case. I mean, photographs are very good. Also, proximity of perception. Secondary victims also have to show that they have witnessed the event in person. Communication through third parties is excluded, and you can cite Alcock itself for this particular proximity of perception requirement. And in Alcock, the court left the door open slightly with regard to live simulcasts. I like watching live sports, and one of the joys of my life is watching live sport. I mean, it's exciting. You know what the word sport means, right? It actually means disport, D-I-S-P-O-R-T. Sport means carry. So sport carries you away from life's serious side. Isn't that lovely? And so, I like watching my live sport, and if it's, really big screen simulcast, and, you see somebody, a relative of yours, killed on the live simulcast, that could possibly be sufficient proximity of perception, particularly with technical advances. It's almost as if you are there. Okay, all right, but no cases on that yet. Might be. Rescuers and employees, do they attract any special attention with regard to duty of care? Well, unless they're primary victims, then of course they can claim for nervous shock, but rescuers and employees normally will not be owed a duty of care. If they are secondary victims, you'd have to satisfy the proximity elements as with other psychiatric injury cases. So if you're a rescuer, you have to show proximity of relationship, which is a little bit unlikely, but still possible. Proximity of time and space, that's probably okay. You'll be there on the actual time and space, probably be satisfied. Perception, probably satisfied. Probably what would not be satisfied with rescuers would be proximity of relationship, maybe. Okay. And there's a case there called White and Chief Constable. White and the Chief Constable is a case saying that rescuers are not given any special treatment. And White and Chief Constable is actually on 2 pages. One's on page 81. So they said, White and the Chief Constable, South Yorkshire. Plaintiffs were the police officers deployed to Hillsborough Football Stadium and who claimed to suffer psychiatric illness as a result of their professional involvement in the disaster. So at the Court of Appeal, the majority held that even though the police officers were not primary victims and did not satisfy the first additional factor imposed on secondary victims, they were nevertheless entitled to succeed on the grounds that they were rescuers. But that goes to the House of Lords, said no special rule for rescuers. If you are a secondary victim who suffers nervous shock, you'd have to prove all the elements of proximity, and it's unlikely that a relative of yours would be one of the ones injured. So you wouldn't have proximity of relationship. Okay, so that's White and the Chief Constable. Rescuers are treated like everybody else. Now on to negligent misstatements. We got into this last time, but we didn't finish this off. So let's go through duty of care owed, where the type of damage suffered by the plaintiff is pure economic loss. And this can be as a result of a negligent misstatement, okay? Can also be a negligent conduct, but we'll get onto that a bit later. Dealing with negligent misstatements first. First of all, what is pure economic loss, everybody? Worth writing down somewhere. I think you should have a must-know definition of pure economic loss. Pure economic loss is loss not resulting from personal injury or property damage, full stop. It's simply when you bought something, you paid more than you should have, that is pure economic loss. You haven't suffered personal injury, you haven't suffered property damage, you've just made a bad bargain, okay? And so there will be no liability for pure economic loss unless the plaintiff can prove this extra element of proximity. And with regard to negligent misstatements and pure economic loss, it's an exceptionally close relationship of proximity. Equivalent to contract, said Lord Devlin. Also, the courts say there have to be 2 elements here. First, an assumption of responsibility, and then reasonable reliance by the other party. So the person making the statement must have assumed responsibility. So normally that's somebody who's an expert in the financial field or whatever field they might be in. In Hedley, Byrne and Hiller, they were financial experts. And reasonable reliance by the other party. Okay. So in Hedley, Byrne and Hiller, the court found that a duty of care could be owed for negligent misstatements causing pure economic loss, providing there was sufficient proximity equivalent to contract. Was there an assumption of responsibility by the statement maker, and was there reasonable reliance by the representee? If there was, then a duty of care would be owed. In Hedley, Byrne and Hiller, everybody, slightly tricky point, but worthwhile going through. In Hedley, Byrne and Hiller, this is where the year is important because you do need to appreciate timing here. Hedley, Byrne and Hiller, there was a disclaimer which was successful in Hedley, Byrne and Hiller, so the statement maker was not liable for negligence. However, Hedley, Byrne and Hiller was decided before the 1977 Unfair Contract Terms Act, And if that were to be decided today, Hedley, Byrne and Heller, it would probably be treated as an exemption clause. The disclaimer would be treated as an exemption clause and would not be effective unless it is reasonable, and probably would not be reasonable. So the disclaimer in Hedley, Byrne and Heller today would not work, probably, under the Unfair Contract Terms Act 1977, which is the English equivalent of our Control of Exemption Clauses Ordinance. Okay, all right. So I'm going to mention that again because there's another case we're going to deal with later called Smith and Bush. In Smith and Bush was decided after the legislation came into being. There was some form of disclaimer, but the court said you're trying to exclude liability for negligence. It will only work if it's reasonable. And in Smith and Bush, that exclaimer was not reasonable, and therefore there was liability in Smith and Bush. Okay, so we'll come to that a bit later. All right, so they're the elements here. Well, first of all, the requirement for a duty of care where the plaintiff suffers pure economic loss is reasonable foreseeability plus proximity, and very close proximity, and you establish the proximity by proving there's an assumption of responsibility by the statement maker and reasonable reliance on it by the other party. So with regard to assumption of responsibility, Chowdhury and Prabhakar is the case in which the young man assumed responsibility for the statement he'd made that the car that the lady was going to buy was worth what she was paying for it. I haven't got the figures, but let's say, I don't know, let's say he said, it's a good car, so she pays 50,000, equivalent of 50,000 Hong Kong dollars, it's only worth 30,000, whatever, okay? So he assumed responsibility, and there was reasonable reliance on that statement by the young lady, and so the court found that there was a duty of care owed. The remarkable thing about Chowdhury and Prabhakar, though, is that it was a contract which was non-commercial, and everybody think, hang on, we think, this, where a duty of care would be owed here when there's pure economic loss, normally it's where you're in a commercial context, okay? And so Chowdhury Prabhakar raised a few eyebrows. It was a split decision, though, in the Court of Appeal, and on page 89 of your course manual, second paragraph, there was a strong dissenting voice by May, LJ, who was of the view that the Hedley-Byrne principle should not be extended to a social context, in other words, domestic context, because it created tension between friends and relatives. Well, certainly it would have created a lot of tension between I'm not sure whether a boyfriend or girlfriend in Chowdhury and Prabhakar, but I presume they're not boyfriend, girlfriend anymore after she sued him. Okay, well, certainly would create tension between friends and relatives, and would make it potentially hazardous to give gratuitous advice. Well, what you should do, everybody, you could still, you don't assume responsibility. You just say, well, don't take my word for it. Okay, I'm not the expert here. That's what you should do. Whether there's reasonable reliance or not, that's a good question as well. Okay, so I'm just getting out my phone here because I did a bit of a screenshot today. I don't know why it does that. And I did a screenshot of a case, aren't I? Yeah. And I'm going to show it. Where is it? Yeah, coming up. Yeah. So on the screen, I've got Chowdhury and Prabhakar, interesting case. So there you go, guys. Precautionary tale. If you're going to advise somebody who's buying something else, what do you think? Should I do this? I'd say, well, I'm not really an expert. Don't take my word for it. Okay, don't assume responsibility. Yeah, I think maybe you should. Okay, but it's up to you. Maybe you should do that. And he's like, well, it looks okay to me. All right, but don't take my word for it. Okay, so his duty of care was held in Chowdhury and Prabhakar, despite it being non-commercial. But it is worthwhile noting that it was a split decision. In the MLC and Everett case on page 89, the court seemed to say Chowdhury is wrong. It should be, the Headley-Burn principle should be confined to cases where the advisor was carrying on the business of giving advice, so such as a professional lawyer or accountant, etc. Okay, so in the MLC case, the court said, hang on, we think Chowdhury and Prabhakar wrongly decided. However, in the Lennon case, now I'll throw in the Lennon case, not in your course manual, the full case name is Commissioner of Police of the Metropolis, presumably London, Commissioner of Police of the Metropolis and Lennon. Okay, Court of Appeal decision from 2004, and in this particular case, a duty of care was held to be owed for pure economic loss following a failure to give proper advice to a policeman who was being transferred within the police force about preservation of housing allowance in the transfer. And the person making the statement did assume responsibility. There was reasonable reliance on it by Mr. Lennon. He suffered pure economic loss. He didn't suffer personal injury or property damage. And the court found that a duty of care was owed to him in the Lennon case. And indeed, they also found that there was a breach of the duty. Okay, so Mr. Lennon was able to claim. There was actually another, we'll get to defences later, but in the Lennon case, there was also an argument that there might have been contributory negligence. But the bottom line is, in the Lennon case, the court found there was a duty of care owed for pure economic loss. Okay, and it wasn't really the same as in the Everett case. It wasn't, the advisor was not somebody in the business of giving advice. So Lennon is a case sort of similar to Chowdhury in that there can be a duty of care owed even where the contract itself is non-commercial. So Lennon is on the side of Chowdhury. Okay. Then I've got the will cases, Ross and Quarters, White and Jones. In Ross and Quarters, White and Jones on page 85, the court extended a duty of care to the beneficiaries under a will. And in Ross and Quarters, Ross and Court is definitely a will case because there was a will being prepared in which two daughters were being cut out because they were not on good terms with their father. But then there was a reconciliation with the daughters, and so the testator, the father, instructed solicitor prepare a new will, giving each daughter £9,000. But the solicitor was a bit slow in drafting the new will, and the testator died before the second will was made. And so the question in Ross and Quarters was, did the solicitor owe a duty of care to the daughters who were the beneficiaries under the will? And the court said yes. Okay. And similarly in White and Jones, which held similarly. Okay, so there's assumption of duty to beneficiaries. Okay, now moving on, how are we going to down to here? Now, reasonable reliance. Some cases here we're going to look at. Normally only in a business context that there'll be reasonable reliance on the statement made because the person making the statement is indeed a professional, so you can rely on them to be reasonable reliance. But of course, we've just noted Chowdhury. It's still possible for there to be reasonable reliance on a statement made by somebody who's not a professional of some sort. Okay. Then we're getting on to some other cases, but everybody, I think it's coming up. Yeah, I think it's good time for my hot chocolate. So we'll have a short break now, 10-minute break. After the break, we'll finish off our work on duty of care for pure economic loss. And then after the break, we'll also get started on breach of the duty of care. So let me just make a little note to that effect. Where are we? Mouse, come in. Everybody, welcome back. So I've got my hot chocolate, isn't it lovely? I'm going to have a slurp. Question from Impact Shing. Going back on the proximity, yeah, I mean, close ties of love and affection. I mean, close ties mean both of you. Like, it has to be mutual, yes. I mean, I can't imagine there'd be a photograph with somebody who doesn't like you. I mean, what they're doing, screwing up their face up, I don't know. And again, it really depends on the facts of each case. And remember, the burden of proof is on the person alleging proximity of relationship. So you'd have to produce the evidence and convince the court, okay? I suppose. And the opposition could say, well, hang on, they could challenge it, say, yeah, you might love her, but she doesn't love you. It does depend on the facts of each case, but I would presume if you've got a photograph, somebody, arm around each other, you wouldn't put your arm around somebody if you didn't like them, would you? Okay. It shows your thinking. I remember one of the points about our course is we focus on, liability, etc. But you you need to appreciate how the court system works. Remember, it's the plaintiff who starts the action, and the defendant is the defendant. And remember, he who asserts must prove. In other words, you've got to produce evidence to prove your case. And watch out for this when we come to breach of the duty of care, which we're going to get on to during this session. Okay? So before the break, though, we're talking about whether a duty of care is owed where the loss suffered by the plaintiff is pure economic loss. What is pure economic loss? Loss not resulting from either personal injury or property damage. Remember, with negligent misstatements, the court's saying, starting from Hedley, Byrne and Heller, there will be no duty of care owed where the loss suffered is pure economic loss unless the plaintiff can establish an exceptionally close relationship or proximity equivalent to a contract. And the two elements there are the assumption of responsibility by the person making the statement and then reasonable reliance on the person receiving the statement. So we looked at this element of assumption of responsibility before the break. Okay. Also on page 90, there's another case called Gorham, which I suppose is worth having a quick look at. And in the Gorham case on page 90, it was a House of Lords decision, and there was a duty of care about insurance policy beneficiaries, and that's an interesting one. I mean, just as a matter of aside, okay, that would be an extension of those cases like Ross and Corters. So there you are. The duty of care has been extended to situations which did not exist before. I mean, Ross and Corters, White and Jones, before Donahue and Stevenson, there's no way a duty of care would be owed by a solicitor to beneficiaries under a will, and or beneficiaries under an insurance policy, as in the Gorham case on page 90. Okay. All right, so is there reasonable reliance on the statement made? Well, normally only in a business context, except, of course, if you can fit yourself into the rather exceptional case of Chowdhury, and perhaps also the Lennon case, all right? And of course, it's usually only reasonable if the defendant has special expertise, okay? And this is our old friend, Howard, Marine and Ogden. And Howard, Marine and Ogden on page 93. Howard, Marine and Ogden, there was reliance. Well, on page 93, Ogden intended to tender for dredging works, and to help compute the tender price, they needed to know the carrying capacity of the ships, the barges. And so Representative Howard Marine provided information to Ogden, which was wrong, okay, because they had separate information apart from reliance on the Lloyd's Register. Okay, it was not disputed that the Lloyd's Register was an authoritative reference for such matters, but in this particular case, there's a mistake in the Lloyd's Register, and the accurate figures were actually contained in the ship's documents, and the person making the statement should have read the ship's documents. And as a result of relying on the incorrect figure, provided by Howard Marine, Ogden underestimated the costs to its tender and suffered financial loss. So this is pure economic loss. Was there reasonable reliance by the representee, Ogden? Yes. By the representor was Howard Marine, and so the court found there was a duty of care there, and indeed negligence. And remember, Howard Marine and Ogden is one of the cases we came across when we dealt with misrepresentation. Remember, if you are alleging misrepresentation, you've got to prove all the elements of misrepresentation, and you also have to state what type of misrep you're going to claim. And of course, you'll always claim negligent misrepresentation because of the misrepresentation ordinance. So remember that. The burden of proof is reversed and put on the representor, and it's a heavy burden of proof as shown by the Court of Appeal in Howard Marine and Ogden, because they relied on the Lloyd's Register of Shipping saying, yeah, this is an authoritative source. Okay, but and of course they relied on it to prove they were not negligent, but the court said, you know, you should have read the extra shipping documents which showed that the figures in the Lloyd's Register were not accurate. Okay, so it shows a heavy burden of proof. And of course, while I'm talking about the misrepresentation ordinance, section 3, remember the level of damages for negligent misrep is the same as for fraudulent misrep. Okay, so that was a pretty bad error on behalf of Howard Marine and Ogden. They were sued for negligent misrep, lost, and so they had to pay damages, and the damages would have been on a fraudulent misrep scale. Okay, and then we've got mispronounced that, she Finance, okay, and Deloitte. Don't think this one's in your course manual, and it's just reliance on an auditor by a lender, and the court found that it was reasonable reliance. So don't worry about the Shui Finance case, okay. And then what about the disclaimer? Now, I've already mentioned this before, and remember, this is where we are going to... that's a good question, Mr. Okay. Yeah, sorry, I'm just reading the chat box. So, is the disclaimer... Now, remember, in Hedley, Byrne and Hiller, decided in 1964, I think it was, before the legislation on exemption clauses, and in England they have a stupid name for their legislation. They call it the Unfair Contract Terms Act, which is stupid because the test is not one of fairness, it's reasonableness, and the Unfair Contract Terms Act doesn't apply to all contract terms, it only applies to exemption clauses. Okay, but in England the legislation on exemption clauses was enacted after Hedley, Byrne and Hiller. And if Hedley, Byrne and Hiller has been decided after the legislation, that disclaimer would have been held to be an exemption clause, and therefore it would not be effective unless it is reasonable. And you would probably guess in Hedley, Byrne and Hiller it probably was not reasonable. Smith and Bush is another case. Smith and Bush, you know, is decided after the legislation came into effect. So the exemption clauses legislation did apply to Smith and Bush. And in Smith and Bush, it was a person who's buying a property, and in order to get the property, the lender, the building society, required a surveyor's report on the state of condition of the premises. Turned out that the surveyor's report was negligent, and so the owner, the potential purchaser sued that surveyor for negligence, and the court found that there was negligence, and there was there was a disclaimer, but the court found that the disclaimer was in effect an exemption clause, therefore the legislation applied, therefore it says that the exemption clause would only be effective if it was reasonable, and the court found that it was not reasonable. Okay, so Also, you could argue there was negligence here for pure economic loss because the defendant had assumed responsibility for the smith and there was reasonable reliance on it by the potential house owner. Okay? And indeed, the House of Lords held it was the house owner who had paid the surveyor's fees, and the surveyor was aware that Smith had relied on the valuer's report without obtaining a second opinion. So there was reasonable reliance and an assumption of responsibility. The loss was pure economic loss, therefore duty of care was owed. Okay, therefore then claim for negligence. But was the disclaimer effective? Well, the court held it was indeed an exemption clause and therefore would not be effective unless it was reasonable. Okay, and so you can see there's a clear overlap here between tort law and contract law. Okay, so if Hadley, Byrne and Heller were to be decided today, that disclaimer probably also would not be effective. Okay. All right, so everybody, that's how we're going. Pretty well it on duty of care. Quick look at pure economic loss, where it's not negligent words, it's negligent acts. And I'm just trying to line up my mouse here. He's got a long way to go. He's got two screens. Oh, there you are. So pure economic loss and negligent acts. Remember, Hadley, Byrne and Heller is a case of negligent words. Okay. And what about pure economic loss and negligent acts? Normally there's no liability. Usually that's the case. Okay. But it's an interesting case, Spartan Steel. This is should know, not really must know. But on page 82 in Spartan Steel, there was electricity, loss of electricity, and that caused loss to somebody who's in the business of processing metal. The electricity supply was suspended for 14 and a half hours. Molten metal was being processed in the furnace when the electricity supply was suspended. In order to avoid damaging the furnace when the molten metal solidified, the plaintiff had to discard the molten metal altogether. After the electricity supply resumed, the plaintiff found it had suffered three losses. Loss of molten metal inside the furnace when the electricity supply was cut off, and then loss of profits that would have been made on the sale of a particular load of molten metal, and loss of profits on the sale of 4 further loads of molten metal that would have been processed within the 14 and a half hours. So the question is, what type of damage was this? And some of them was pure economic loss, and the other one was directly caused loss. And the court found that the plaintiff could only claim for loss which was directly caused, not for loss of profits on the unprocessed meal, because that was pure economic loss. Okay, so there you are, that's negligent acts. Should know, not must know, Spartan Steel. Pure economic loss and negligently constructed buildings though, so we're looking at negligent acts here with regard to buildings, okay, and remember, if you buy a defective building and you suffer loss, well, that's pure economic loss. Is a duty of care owed to you? Well, only if you can show sufficient proximity, okay? Despite the fact that the building may be in imminent danger of collapsing, you've simply made a bad bargain. And Murphy and Brentwood overruled Ains and Merton in this case. In Murphy and Brentwood, the House of Lords said that this is pure economic loss. A duty of care will only be owed if there is sufficient degree of proximity, okay? By the way, there's a case in Hong Kong called Sunface International, which preceded Murphy, and the Hong Kong courts came to the same conclusion. So Hong Kong sort of led the way here. So the courts will not find there's a duty of care owed to the plaintiff who suffers pure economic loss unless you satisfy not only reasonable foreseeability but also sufficient proximity. So the Hadley, Byrne and Heller criteria are applied to negligently constructed buildings. Okay. Should know, not must know. You won't get this in the exam, but it does show you that the courts have moved with the times. All right, so let's review all of duty of care. Okay, so what I've tried to do here, everybody, is to encapsulate in one PowerPoint all the important points with regard to duty of care. Okay, and we focus on the harm to the plaintiff. What damage has the plaintiff suffered? Well, as we've noted several times tonight, if the type of damage suffered by the plaintiff is directly caused personal injury or property damage, Donahue and Stevenson, that's it. A duty of care will be imposed. You just have to show reasonable foreseeability, and that normally is not an issue. Okay, so in a traffic accident case, if the plaintiff suffers personal injury or property damage, is the duty of care owed? Yes, full stop. And indeed, you could cite case law which says that all car drivers owe a duty of care to all other road users, including pedestrians. So if you get a question in the exam involving a traffic accident, by all means tell the examiner you know what duty of care is. Well, first thing you would do in your answer is write down the elements of negligence, and then you would have a heading duty of care, just say clearly a duty of care is owed, Donahue and Stevenson at House of Lords, that's it, full stop. You don't need to go into further analysis. If it's directly caused physical damage, that's it, okay? However, if the type of damage suffered by the plaintiff is other than directly caused personal injury or property damage, such as nervous shock or your economic loss, then you've got to go further. With regard to nervous shock, don't forget, make sure you tell the examiner you know what nervous shock is, Hinds and Berry, a medically diagnosable mental illness. Okay. And then distinguish between a primary victim and a secondary victim. Page and Smith is your second must-know case on nervous shock. Primary victim, remember, one who is either physically injured and then suffers nervous shock, or is in the line of impact, in fear of his own safety. You're a primary victim. You only need to show reasonable foreseeability, Page and Smith. However, if you're a secondary victim, okay, then you need to show not only reasonable foreseeability, but also those elements of proximity laid down in Alcock. You've got to show proximity of relationship, Alcock itself, you could cite, proximity of time and space, McLaughlin and O'Brien contrast Chung and Lamb, okay, and perception, and again, Alcock you can cite, okay. So everybody, the second bullet point, very, very important, comes up quite often in exam questions, not difficult. Normally students handle this quite well, but make sure you're clear on the distinction between a primary victim and a secondary victim. A primary victim who's one who's either suffers physical injury and nervous shock, so he's affected both physically and mentally, or somebody who may not have suffered physical injury but is in the line of impact, so he might not have actually been injured, but if you're in fear of your own safety, such as, you know, a near miss, you're walking along a pavement and something falls like an air conditioner right in front of you, well, if you suffer nervous shock, then you would be a primary victim. Yeah? However, if you're not a primary victim and you suffer nervous shock, you'll be a secondary victim, and you need to show those elements of proximity. Proximity of relationship, time and space, and perception. Okay, got it. Okay, now with regard to pure economic loss, again, make sure you know what pure economic loss is. That is not result of physical injury or property damage. Okay. So pure economic loss is financial loss, if you like. And so for a duty of care to be owed to you who suffers pure economic loss, you have to show reasonable foreseeability plus proximity, and the proximity is very close proximity, a special relationship equivalent to contract. Okay, and Hedley, Byrne and Heller says that. Hedley, Byrne and Heller is the leading case on negligent misstatement, but also White is a case that says that the Hedley-Byrne principle can be applied where the pure economic loss is caused by negligent conduct, not just words. Okay, so you've got to prove that closeness, that proximity. Okay, if you can do that, fine. And you prove the proximity by showing an assumption of responsibility by the person who's made a statement or done the act, and reasonable reliance. That's with regard to negligent words. Okay, so that's as close as I can get to a perfect PowerPoint on the overview of duty of care. And remember, whether duty of care or how big an issue duty of care is depends on the type of damage that the plaintiff suffers, the harm to the plaintiff. Okay, so put a big circle around this PowerPoint, must know, because there are other cases there I must know as well. I haven't got Hinds and Berry, for example, on nervous shock. Okay. Yeah, most of them are there. Okay, right. So that's it on duty of care, everybody. Well done. We've covered the first big elements of negligence, and of course the next big elements of negligence will be breach of the duty of care. So just give me a minute while I set up the PowerPoints for breach of the duty of care. Ta-da. Oh, smooth. Well done. Did that well. I'm always nervous with my PowerPoints. It's good with two computers because I don't seem to have that much trouble as I sometimes have with one screen. Okay, good. So let's have a look at breach of the duty of care. Now I'm telling you, everybody, if there's a traffic accident, breach of the duty of care is always an issue, okay? So with regard to traffic accidents, and they're the common scenarios in exam questions, is the driver, whoever it is he liable for negligence? Well, you've got to prove all the elements of negligence. We've covered duty of care. Duty of care is normally not a big issue with regard to traffic accidents because the damage suffered will be directly caused personal injury or property damage. The issue with traffic accidents is usually, is there breach of the duty of care? Watch out for that. All right, so a quick reminder of the elements of negligence. So remember, any time you do a question on negligence, first thing you do is remind the examiner you know what the elements are. A duty of care owed by the defendant to the plaintiff, and then there must be breach of the duty of care causing damage. Okay, perhaps I should correct, so it's A, B, C, D. All right, so we're going to be focusing on the second bullet point now. How do you know whether there's breach of the duty of care? Well, that depends on what the standard of care is. So how does the court decide what the standard of care is? Good question. We'll be looking at some cases which illustrate how the court does that. So, breach of the duty of care. And we're back, of course, into Chapter 2 of the course manual. Remember our order of topics. We cover all there is to know, need to know on duty of care first, and then we're going to deal with the second element, which now, of course, is breach of the duty of care. So the standard of care, of course, will vary in certain circumstances, okay? And we'll see how the court decides this. And of course, defendants will be in breach if their conduct falls below that which was reasonable to expect of them in the circumstances. So this word reasonable is a key to the standard of care. So the overriding guiding principle is reasonableness. And the ultimate purpose is to avoid actions that cause injury or harm to another person, obviously. So, in short, where duty of care exists in a given circumstance, the law of negligence requires a person to take reasonable care so to avoid the risk of causing injury, loss, or damage. So how do you know what the standard of care is? Well, the standard of care is the standard of the reasonable person. Who is this reasonable person? Well, it's the reasonable person in the place of the defendant, if you like, the standard of the reasonable defendant in the circumstances of the case. Okay, and of course, it's an objective standard. determined by the judge in a particular case. A must-know case dealing with standard of care is Glasgow and Muir on the screen. And in Glasgow and Muir, where are the facts? It was somebody who was, it's on the facts actually on page 49. A reasonable man is presumed to be free both from over-apprehension and from over-confidence. Are you a reasonable person? Good question. What do you mean by reasonable? Okay. So in Glasgow and Muir, Glasgow owned a house that was used for selling tea and ice cream. Oh, isn't that lovely? Tea and ice cream go together? I suppose they do. A picnic party was held in the tea room where two men from the party carried heavy urns of hot tea into the house. Get the picture? While some children were buying sweets and ice cream at the counter. Okay, so one of the men lost his hold on the urn and the hot tea spilled on the children. Ouch. So they were injured, personal injury. And so the children, or the parents, sued the manager of the house for negligence in allowing the two men to carry the hot tea around children. So, was a duty of care owed? Yes, it was. No problem with that. But was there breach of the duty of care? Well, this is the standard of the reasonable person in the circumstances, standard of the reasonable defendant in the circumstances. And the court found that in this particular case, that the defendant had done everything reasonable to protect people from being injured. This is just on the facts itself. I mean, short of telling everybody to go home, there's no way that Glasgow Corporation could have totally avoided an accident occurring in which tea might have been spilled on somebody. Okay, so on the facts, the court found that there was no breach of the duty of care in Glasgow and Muir. Okay, the Glasgow and Muir had done everything reasonable that they could have in the circumstances to make the situation safe. Okay, and of course the reasonable person doesn't exist in fact, rather exists in the mind of judges. It's up to the judges, and the courts attribute to the reasonable person subjective elements when circumstances so require. Okay, so there you are. Simply on the facts of the case, the court found that there was no breach of the duty of care, therefore no negligence, because they said that the reasonable person in Glasgow's position had done everything reasonably possible to protect against injury to anybody at the party. And the only thing they could have done to totally do is tell everybody to go home, and that was not reasonable. Okay, well, that's what the court said. And of course, reasonable is up to the judge. I mean, sometimes hard to understand why is it reasonable here and not other places. It did go all the way to the House of Lords, so you can see there are arguments for here, because there's no absolute standard. It varies according to the risk involved. Okay? So there you are. In other words, it's really up to the judge or the court in a particular case. But what we do take away from Glasgow and Muir is that the standard of care changes. It varies from case to case. There is a notable exception to that, and we're coming up to it in a moment. First of all, let's have a look at minors, children under the age of 18. What is the standard of care for children? Well, the courts will say it's that of an ordinary child of that age. Okay, so some interesting cases here. First of all, the Australian case, McHale and Watson on page 50. Plaintiff was a 9-year-old boy. Girl. Oh my goodness. And the defendant was a 12-year-old boy. So the boy was trying to throw a sharp metal spike into a wooden post a couple of feet away. Well, kids do this, don't they? The spike bounced off the post, struck the girl who was standing a few feet away from the boy. So hang on, was there breach of the duty of care? Well, what's the standard? The standard is that of an ordinary 9-year-old child, okay? And the court said, well, hang on, 9-year-old kids do these sort of things. And so they found that there was no breach of the duty of care. The High Court of Australia, which is their court of final appeal, said the standard of care being objective is no answer for a child any more than it being for an adult. So you've got to look, we look at what is the standard of an ordinary child 9 years old, okay? And similar situations, Chan and Wong, again on page 50, plaintiff and defendants were both 14-year-old boys while they were engaged in a mock sword fight, Star Wars and all that, with their T-square drafting instruments. One of the instruments struck the plaintiff in the eye. Ouch. So the court refused to hold the defendant liable. Although the court made no reference to the reasonable standard for a 14-year-old boy, the court found there was no evidence that the defendant conducting himself recklessly or with a high degree of carelessness, which is interesting. A 14-year-old, you're getting a bit more responsible, but the courts look at the standard of an ordinary child of 14 years. And children of 14 years old do these things, I suppose. I can't remember when I was 14, did I do that? And then Orchard and Lee, more recently, 2009, similar thing. Fortunately, I like this one because this is really stupid, and the adult's pretty stupid. 13-year-old student while playing tag on the school playground. Well, what do children do, particularly when you let them out of a class? They run around. Oh my goodness, around the playground. He ran headlong into the lunchtime supervisor. He got injured. Okay. Student was found not to be negligent. Why? Because 13-year-olds let out of a classroom are going to run around the playground, and if they run into a supervisor, well, perhaps the supervisor should have been somewhere else. Okay. So there you are. The court found there was no liability in Orchard and Lee. Okay, it must be careless to a very high degree. The student was running within a play area, did not break any rules, nor was he acting to any significant degree beyond the norms of the game being played. There was some sort of game. All right, so there you are. In all of these cases, the child was not in breach of the duty of care. There was no negligence in any of those cases. The standard is that of an ordinary child of that particular age. Okay, now what about people who have special skills or competence? What is the standard of care for them? Well, there are industry standards. For example, the Law Society has standards, the Bar Council has standards. Every professional has their own standards, okay? And the leading case on sort of experts is the medical case of Bolam. I'm not sure where Bolam is in your course menu. It's Bolam, anyway. Here it is, it's on page 52. Bolam, page 52. Yeah, we've got Bolam. And I've got a separate one on Bolam coming up. So there are two cases to look at. One is Bolam, the other one is Wong and JSM. I want to look at Wong and JSM first, because that concerns us lawyers, because the person involved was a young solicitor. Where's my mouse? I'm looking for my mouse again. Come in. There you are. Okay, let's have a look at Wong and JSM, because this is an interesting one. It's on page 52 of your notes, but your course manual is a little bit lacking a bit on this case. I'll explain why. So in Edward Wong and JSM, Johnston Stokes and Masters, one of the premier law firms in Hong Kong, or at least it was. So there's a young solicitor involved, a young lady. She'd been qualified about 2 years, I think. And in Hong Kong, when you buy land, it's a two-stage process. The vendor or purchaser sign an agreement for sale and purchase, yes, and then there is a second stage called the completion stage, where an assignment is completed which transfers the legal title from the vendor to the purchaser. Now, when you buy something, everybody, let's say you're buying, I don't know, a smartphone. Normally you pay your money over at the same time you get your smartphone. Simultaneous exchange of money and items, okay? So when you buy a car, you pick up the car and you immediately pay. So normally when you buy anything, it's simultaneous exchange of money and whatever you're buying. Interestingly, in Hong Kong, it doesn't work that way with land, which seems a bit odd because land is much more valuable than most other items you might buy. In Hong Kong, it's non-simultaneous exchange of money and title documents. What happens is that the purchaser pays over the balance of the purchase price, but doesn't get the title documents till about 6 weeks later. Okay, so there is a time gap. I mean, when I bought my flat, my wife said to me, "So you've given them the money?" "Yes." "Did you have a..." Hang on. No, in McHale and Watson, it's a 9-year-old because it was the defendant was 9-year-old. Okay. Yeah, sorry, quite right. It should be 12-year-old. It doesn't matter. I'll amend that later. Quite right. Yes, Michaela Watson, he was 12. Okay. Correct. I shall amend that later. Yes, do make these little points. It says 12-year-old. Okay. So I'm just checking the chat box. So Watson was 12, but it doesn't matter. It's 12. Girls. All right. Okay, so modern JSM. So what happened here is that what happens with the balance of the purchase price? Well, it's paid by the purchaser to the vendor solicitor, who then hangs on to it and should put it into a trust account. And of course, the vendor solicitor is only holding the money on trust for the vendor. But what happened and of course then the money is transferred to the vendor. But in the meantime, the money is sitting in a trust account and the vendor solicitor is the trustee. So theoretically, the vendor solicitor can withdraw the money and abscond with it. Of course, you shouldn't do that because that's a serious breach of trust. Okay, and so what happened in JSM, the vendor solicitors did withdraw the money and absconded with it. So who's unhappy with this? Well, the purchaser. So which means the purchaser had to pay the balance of the purchase price again. So he sued the young lady for negligence. Okay? And the young lady said, "Hang on, what is the standard of care for a solicitor in these circumstances?" "Well, I'm just following the normal practice in Hong Kong, because completion by undertaking is called the Hong Kong method of completion." And the Hong Kong Court of Appeal agreed with the young lady solicitor, said, "Hang on, the standard of care is that of, what's the normal practice in Hong Kong?" And, well, she's just following the normal practice. No breach of the duty of care, okay? But no, went to the Privy Council, and the Privy Council reversed the Hong Kong Court of Appeal. And this is where I think your course manual's wrong, because the course manual says the Hong Kong Court of Appeal said there was no negligence, and then the decision was affirmed, but it wasn't actually, it was overturned by the Privy Council. So your course manual's wrong there. So the Privy Council said there was negligence. Why? Because there was a special risk involved in Wong and JSM, because the vendor solicitor was a one-man law firm. Now, with a one-man law firm, you only need one signature to withdraw the funds from the trust account. In most law firms, there are at least two signatures required to withdraw money from the trust account. But in Wong and JSM, the vendor solicitor was a one-man law firm. And this was a special risk which should have been mentioned to the purchaser. And so and if that was mentioned to the purchaser could have insisted on completion not being by undertaking, but could have been should have insisted on what we call formal completion, that is simultaneous exchange of money and documents. Okay, so the solicitor should have pointed out these risks associated with the vendor solicitor being only a one-man law firm, did not do that, and so they were in breach of the duty of care. And so there was negligence found in Wong and JSM. The Privy Council did not affirm the Hong Kong Court of Appeal decision. They overturned the Court of Appeal decision and found that there was indeed negligence. Okay, so your course manual is wrong on that. So that's on page 52. Might want to make the correction. By the way, the standard form contract in Hong Kong has been amended now, and so the contract says that when the balance of the purchase price is paid over now by the purchaser to the vendor solicitor will hold it as agent of the vendor, which means what? If you pay an agent, you paid, you don't have to pay again. So that has now been made clear. It wasn't made clear before. Okay. All right, so there you are. That's a land law case, but it does show that the standard does depend on who the defendant is. The defendant here was a solicitor. Hong Kong Court of Appeal said no breach of the duty of care, just following normal practice, but the Privy Council said no. There's special risk associated with the vendor solicitor being a one-man law firm, and that should have been pointed out to the purchaser. It wasn't done, therefore there was a breach of the duty of care. Okay, so interesting case. By the way, in Hong Kong, all solicitors carry insurance for negligence. I guess their premium went up a bit after that. So what happened in the Bolam case? Bolam again on page 52, again sort of says sort of the obvious that, in a way. What is the standard of care of, a professional doctor? Well, it will depend on the standards of a reasonably competent medical man at the time. So the court will have to, the court will be listening to expert evidence given by people who are experts in this area. Okay, and so this is a matter of expert evidence being given in a particular court. So you have to come up to the standard of a reasonably competent medical practitioner, whatever that is at the time. Okay, and there may be one or more perfectly proper standards. So it does really depend on what the expert evidence presented to the court is. Also, interesting case, and this is one we're going to come to later. What is the standard of care of a reasonable employer? Good question. Well, in Wong Kit Chun and Wishing Long Hong, a very important case, this one, because it is a case on two separate issues. I call it the Wishing Long Hong case because that sounds better. It went all the way to the Court of Final Appeal, and it concerned an employer who was sued for negligence by the widow of one of the employees who was killed. Now, how did the employee die? Well, the employee was travelling in Huangshan on the mainland on business, and there was an inspection arranged early in the evening, early in the morning, I think, to inspect some mountains with an eye towards investing in the area. Okay, so they went along the White Goose Ridge, wherever that is, very early in the morning to view the sunrise. Well, wasn't that nice? Plaintiff's husband fell into a rain ditch due to poor lighting and was killed. So, why was he killed? It was simply because there was insufficient lighting provided. I think there was something like, don't quote me on the numbers, 9 people and 5 torches. So not everybody had a torch. And the person who was killed did not have a torch. So, was the employer liable in negligence? Well, did the employer owe a duty of care to the employee? Yes, even before Donoghue and Stevenson. employers owe a duty of care to employees. Was there breach of the duty of care in the Wishing Long Hong case? The court said yes. Well, what is the standard of a reasonable employer? Well, the standard would be a reasonable employer would spend a little bit of money. Tortures are not expensive, and they should have spent a little bit more money and making sure that every person who was walking along White Goose Ridge had a torch. And they didn't, so the court found that they were in breach of the duty of care. Causing damage, yes. So the employer was liable for negligence in Wishing Long Hong. One of the other issue that comes up in Wishing Long Hong is was there a defence of contributory negligence? So watch out for that. Wishing Long Hong, I'd say a must-know case, because it's a case on whether there's breach of the duty of care by an employer. The standard is that of a reasonable employer, and there was breach because they provided insufficient lighting, insufficient torches. Okay, but the employer argued there was contributory negligence in Wishing Long Hong and actually succeeded in that. And we'll see contributory negligence is a partial defence to a claim for negligence. And I think in Wishing Long Hong, the quantum of damages was reduced by about, I think, 10%. Okay, 10% in Wishing Long Hong. Okay, so good case. So there was breach of the duty of care in Wishing Long Hong. Also, I've got another case there. I don't know why I got this case, but I always put it in. Showing and lamb's not in your course manual. I think what happened was that some people were feeding monkeys in Kowloon somewhere or other, and the monkeys bit them. And was there negligence? Well, duty of care was owed, yes, but was there breach of the duty of care? Well, the court said no breach, because I think there were warning signs there, and the people feeding the monkeys were stupid themselves. Anyway, I'll just throw that one in, a bit of monkeying around. But Wishing Long Hong, that's your must-know case. It is court of final appeal. It's a good case on breach of the duty of care by an employer. Okay, so that brings us on to other factors the court might take into account in deciding whether there is a breach of the duty of care. But I think it's probably time for our second break. So I'll put that in now. Where are we? There we are. Okay, everybody, into the final stretch, as I've got in the chat box. And also, thanks to Learn Came Soon. Yes, Watson was 12 years old, so the defendant should be. I've amended the PowerPoint, okay. Although the general point remains the same. The standard of care is that of a child of that age. Okay, ordinary child of that age. Okay, good. So moving on to other general factors the court can take into account in trying to find out what is the standard of a care in circumstances. Okay, so some interesting cases here. Obviously, they look at the magnitude of the risk and likelihood of occurrence. What is reasonable. Okay, and Bolton and Stone, often cited in books of good tort law books. Bolton and Stone, I used to play cricket. I was a good cricketer, played for Hong Kong, Player of the Year in 1980, got the trophy to prove it. Also, I got hit in the head once playing cricket. I was in Queen Elizabeth Hospital for one night, front page of the South China Morning Post. Discharged myself after one day because the guy next door to me died and I didn't like the congee. Anyway, yeah, cricket. You can get injured. The cricket ball's hard, okay? And in Bolton and Stone, somebody was hit by a cricket ball, sued the cricket club for negligence. Well, was the duty of care owed? Yes, but was there breach? Good question. Well, on the facts, the court found that the risk of this actually happening was so small that a reasonable man in the position of the cricket club would have thought it right to not have to take extra steps to protect the public, because the ball was only hit out of the ground 6 times in 30 years. They mustn't have been very good players, or it must have been a huge cricket ground. I don't know. So the court found there was no breach. If you go past the Hong Kong Cricket Club these days, Hong Kong Cricket Club used to be where Chater Garden is now. It got kicked upstairs to Wong Lee Chong Gate because of the MTR being built. And so if you go to the Hong Kong Cricket Club now, on your way to Repulse Bay along Wong Lee Chong Road, you will find that there is a fence there which is very high. It's about 30 feet high. Why was that? Well, because there was a cricketer in Hong Kong some years ago who was pretty good, and he hit the ball out of the ground something like 10 times in one afternoon. So if you're driving your car up along that road, Wong Lee Chong Road, watch out, you could have had your windscreen smashed and all the rest. Okay, so the cricket club did decide, hang on, the magnitude of the risk was worth taking these extra steps, so they bunged up a netting type of thing, 30 feet high, okay? So I don't think any cricket ball's ever been hit out of the Hong Kong Cricket Club since then. All right, Bolton and Stone, different though. Okay, so no breach of the duty of care in Bolton and Stone because the magnitude of the risk was extremely small. Latimer is an interesting one, which I don't actually is in your course when you're Latimer, but if you have a floor which is wet, and when I leave my room tonight, where I'm in room 301, yes, there's normally a cleaner doing something on the floor, and they normally have a sign, okay, but I think what happened in Latimer, there was not just water, there was oil on it as well, and it wasn't all removed, so somebody came along and slipped over and got injured. And the court found that there was breach there because they should have put up warning signs or something. Also, Paris and Stepney is an interesting one because this looked at the gravity of the injury. And it's an interesting one because in Paris and Stepney, it was an employee who only had one eye. Okay, now everybody, if you got 2 eyes and you lose one eye, well, that's pretty bad, but not absolutely catastrophic. But if you only got one good eye and you get damaged in that eye, well, bingo, you are in a lot of trouble. Okay, my PowerPoint says pellet with one eye damaged in the other eye. Okay, well, anyway, so he's actually damaged in his one good eye. So the court found there was breach because employer owed a duty of care to take reasonable precautions against injury to every individual employee. The more serious the damage which will happen if an accident occurs, the more thorough are the precautions which an employee must take. So if you only got one good eye, you don't want to be, it's much more serious if you lose that one good eye. And so the precautions should not be the same for each and every employer. The employer here should have taken more precautions with regard to the plaintiff than for other employees, given that the plaintiff was already blind in one eye. Okay, so he's with one, like I said, with one blind eye. Okay, damaged. Actually, I'll put that in because I'm always working on with one blind eye. Okay, where are we here? Okay, I'll add this in. Okay, here. Blind eye, one blind eye. There you go. Okay. What happened to that? Oh, there you go. Blind eye. Okay, good. Save changes. Where are we? Okay, file, save changes. Or save anyway. All right, okay, so it's one blind eye damaged in the other eye. Well, obviously now he's totally blind, so obviously it's much more serious than if you've got two eyes and lose just one. Okay, and then another interesting one is De Bourne, Second World War case. Plaintiff was driving a left-hand ambulance in England during wartime. Now, of course, you know the history here. The English were in desperate straits. I mean, they nearly got in, except, because of the Battle of Britain. Britain was sort of saved, but then they badly needed help. And so when the Americans entered the war, they were definitely a big help to the English, such a big help that the English had run short of ambulances. So the Americans shipped over American ambulances, but of course they drive on the wrong side of the road. Okay, and this ambulance, the American ambulance, was involved in an accident. A notice was posted at the back, caution, left-hand drive, no signal. Well, as there was an accident, and sort of caused by the fact that these ambulances were not English ambulances, but the court said, hang on, this is a great, the donation of the ambulances was of great social utility, and the purpose to be served was sufficiently important to justify the assumption of abnormal risk. So there you are. There could be social utility. Also, it could be a situation, for example, where there's some sort of emergency and you're on your way to a hospital because people are about to die, that sort of thing. That could be a factor the court takes into account. Obviously it's important to save lives. So it does depend on the facts of each case. So these are just sort of illustrations, if you like, of what sort of factors the court might take into account in deciding whether there's breach of the duty of care. I think most of these cases everybody should know, not must know. What are the must know cases going back? I would say the must know cases, just quickly recapping breach so far, definitely Glasgow and Muir. Glasgow and Muir says that the standard of care varies depending on who the defendant is. That's Glasgow and Muir. It's a varying standard. And of course, it does depend on who the defendant is. And for minors, it's the standard of an ordinary child of that age. And then for professionals, well, we'll have to look at industry standards to decide, okay? And the standard of care for solicitors, well, there you are, got that there, okay? And then for doctors, it's the Bolam test. Again, it depends on the professional evidence, expert evidence produced. An employer, though, the standard of care for an employer is that of a reasonable employer. So wishing long harm, okay, a reasonable employer would have provided sufficient tortures to people in that situation. And then the court will look at other factors because you're trying to decide, what is reasonable in the circumstances. Okay, other factors, well, the difficulty of overcoming the risk in general. Of course, we look at wishing long hong again, in that the employer was killed on the early morning trek in the PRC. Obviously, it was not very difficult to overcome the risk there, just by a few more tortures, okay? The wagon mound is often thrown up as a case here. The difficulty of discharging of oil, it could have been easily prevented. So, it depends on the facts. Removal of oil was easy, it was not costly. And that was a factor the court took into that. And of course, with regard to professionals, the court will look at professional or industry standards. If you're a driver in Hong Kong, there's the Road Users Code, which I did look at one stage. If you're a banker, there's the Code of Banking Practice. I was looking at that when I was in-house with Citibank years ago. Legal practitioners' rules for solicitors. So if you ever become a solicitor, you'll be given a copy of the legal practitioner rules, and you should follow those. And then for barristers, they follow the bar code. Okay? And of course, with regard to solicitors, we've got Wong and JSM. And although in Wong and JSM, even though conveyancing was the normal practice in Hong Kong, that wasn't sufficient to save the young lady solicitor. She was still found to be negligent. She was in breach of a duty of care because of the extra risks involved with the fact that the vendor solicitor's firm was a one-man law firm. Okay, everybody, we come on to a very important case, very important because it often comes up in exams. It is must know. What is the standard of care for drivers on the road? And the answer is on the screen. The standard of care required for a driver is the standard of the competent and experienced driver. The competent and experienced driver. Okay, and this is shown in the case of Nettleship and Weston. Nettleship and Weston is a must-know case, and it's a must-know case in any situation involving drivers because it gives us the standard of care for car drivers. Okay, now unfortunately your course manual is a bit weak on Nettleship and Weston. It does actually mention it at the bottom of page 32. It also mentions it right at the beginning of chapter 2. Down the bottom of page 32, it does give you the facts of Nettleship and Weston. Weston was learning to drive from a friend. So she's a learner driver, and her friend was the instructor. The instructor was injured when the learner driver crashed the car due to nervousness. Yes, aren't you nervous when you get behind a car? And experience. And so the driving instructor sued the learner driver for negligence. Did the learner driver owe a duty of care to the instructor? Yes. That's Donahue and Stevenson, okay, because it's directly caused personal injury. Was there breach of the duty of care? And the court said yes. But the learner driver said, hang on, I'm only a learner. I can't be expected to drive as well as an experienced driver. And the court said, no. Even though Glasgow and Muir says the standard of care for the defendant varies, depends on the reasonable defendant in the circumstances, the law is different with regard to drivers. This is very important. There's only one standard for car drivers. Only one standard. And that is of a competent and experienced driver. Now, of course, the reason for that is to protect the public. Okay? I mean, you can't have a learner, oh, sorry, I hit you, I'm only a learner, but you still get injured. So in order to protect the public, there's only one standard of care for car drivers. Most important, okay? And the standard of care is that of a competent and experienced driver. And a competent and experienced driver wouldn't have caused the accident occurring because of the crashing of the car, okay? A competent and experienced driver wouldn't be so nervous, okay, and inexperienced. And so the learner driver was in breach of the duty in Nettleship and Weston. Interesting. And we'll come across this later, but the interesting thing about this case was that the plaintiff in the case was the car instructor. You might say, well, hang on, he's not a very good instructor if the learner driver crashes. And indeed, the court found that the instructor was partially at fault and reduced the damages because of contributory negligence by 50%. So that's an interesting case. So Nettleship and Weston is a good case because it has two issues in it. It's a bit like the Wishing Long Hong case. Let's go to look at Wishing Long Hong when it comes to contributory negligence later. Okay. So remember, we're in a civil action. Plaintiff takes action, sues the defendant. Plaintiff has to prove all the elements of negligence. Good. But the defendant can raise a defence. And the most important defence is contributory negligence. There are other defences, but the most important defence to negligence is contributory negligence, where the plaintiff is at fault themselves. And the plaintiff in Nettleship and Weston, the instructor, was at fault He should have done a better job. Should have been a better teacher, but he wasn't. So I like Nettleship and Weston because it's important law for car drivers. So Nettleship and Weston is an exception to the Glasgow and Muir principle. Glasgow and Muir says the standard of care varies depending on who the defendant is, okay, but Nettleship and Weston says, hang on, no. There is no varying standards of care when it comes to car drivers. There's only one standard, and that's of the competent and experienced driver. Most important. Okay, and Nettleship and Weston is mentioned at the bottom of page 32. That does actually mention that the Court of Appeal refused to impose varying standards for drivers of different skill and experience, which is a bit strange because this is the leading case on breach of the duty of care. For some reason, your course manual's got it under 2.1. It doesn't actually mention it under breach of the duty of care. So everybody take a note of this PowerPoint. Very important. You get any question in the exam involving a traffic accident, then of course, what are the elements of negligence? Well, obviously a duty of care will be, assuming it's directly caused personal injury or property damage, so just cite Donahue and Stevenson for the duty of care. Then you get on to the second element of negligence, is there breach? And you go straight to Nettleship and Weston, and you would have to consider whether there is breach of the duty of care. What is the standard of care? It's that of the competent and experienced driver. And you might be given some facts in the question, he might have driven quickly, but there might have been an accident. If there's a traffic accident, does that mean that the driver involved is at fault? Not necessarily. It depends on the circumstances. Okay, you might have been trying to take evasive action because somebody's coming at you on the wrong side of the road, that type of thing. So if there's a traffic accident, it doesn't mean there's breach of the duty of care. It does depend on the circumstances. Okay. All right, so that's a very important case on the screen. Put a big circle around this PowerPoint or whatever, highlight it. Nettleship and Weston is must know. It's a very important case on car drivers, okay? The standard is that of the competent and experienced driver. So the court found that the learner driver was in breach of the duty, okay? So there you are. No varying standard of care for car drivers. So those of you who are driving a car these days, watch it. Okay, even though you're a learner driver, you will be held to the standard of a competent and experienced driver. Okay, everybody. Now I'm going to give you a couple of extra PowerPoints here, one of which is not in your course manual. It should be. And I think you'll agree with me, it should be when we go through it. And that is, if I can get the mouse in the right position. Come on, mouse. Oh, there you are. Okay. All right, now let me put it to you, everybody. You are in a car accident and you're knocked unconscious. You sue the driver involved for negligence. Well, no problem with duty of care. How are you going to prove a breach of the duty of care? Good question. You have to produce evidence to prove there's breach. All right, but how can you do it if you're knocked unconscious? So the judge will say, sorry, I had no idea I was knocked unconscious. So how are you going to prove your case? So there are two important aids in proving breach of the duty of care. One is section 62 of the evidence ordinance. This is not in your course manual. It should be, because section 62 is very important. Section 62 says, evidence of any relevant criminal offence is admissible in the civil action. So what would be a relevant criminal offence? Well, if the driver involved was charged with careless driving or drink driving or any relevant criminal offence, the evidence of that conviction can be adduced as evidence in the civil action. And that's very cogent or powerful evidence, because if you're convicted in a criminal court, the standard is higher than in a civil court. The standard of proof in a criminal action is beyond reasonable doubt. The standard of proof in a civil action is on the balance of probabilities. So this is very, very powerful evidence that a plaintiff can rely on to prove breach of the duty of care. And this is section 62 of the evidence ordinance. Another useful part of section 62 is section 62 sub 2, which says the legal burden of proof shifts to the defendant. And that can be crucial. So if you're alleging negligence, then the defendant will have to prove he's not negligent. And that's very powerful assistance to the plaintiff. So what's on the screen, everybody? Very important. I say must know. Get any question in the exam dealing with breach of the duty of care, particularly with car drivers, then section 62 is very valuable assistance. Okay, I challenge you, everybody, get on your smartphones, check the evidence ordinance, check section 62. The wording's quite clear. Okay, so there you are, and very, very important. I think you'll agree with me, it's very, very important. And I mean, you might remember there's a case, famous American case called O.J. Simpson. He was convicted of murder. He was charged with murder of his wife and boyfriend. He was acquitted of the charge of murder, so he won his criminal case, but then he was sued in a civil action, and the civil action succeeded because the standard of proof is different in a criminal action from a civil action. So if you can produce evidence of a relevant criminal offence, that's very strong evidence assisting you in proving breach of the duty of care. And the other one, which I'll go through now, it's getting a little bit late, but I'll go through it quickly and we'll review this again when we meet again, which is Tuesday next week. There is another aid in proving breach, and this is actually mentioned way back in page 15 of your course manual, but very briefly, and I've expanded on this, and it's a Latin expression called res ipsa loquitur. So it's under the heading 1.4.4 on page 15 of your course manual. It's a Latin expression meaning the thing speaks for itself. Okay, the thing speaks for itself. And it's a rule of evidence relied on by the plaintiff to prove breach of the duty of care. Okay, and the test is the thing, whatever it is, and in some of the cases we look at, it's a crane which is operated, any sort of machinery or the thing, whatever that is, under the management of the defendant, and the accident is such as in the ordinary course of things does not happen. If the defendant uses proper care, then the thing speaks for itself, okay, and that's very powerful evidence again to help the plaintiff prove breach of the duty of care. And the leading case on this is not in your course manual, so you might want to make a note. It's called Scott and London and St. Catherine Docks. And in the Scott case, it was a crane which collapsed and people got injured, and the court found res ipsa loquitur existed. The crane was under the management of the defendant, and the accident was such as in the ordinary course of things would not happen if the defendant used proper care, and so the thing speaks for itself, and so that was useful evidence for the plaintiff to prove breach of the duty of care. Now, important point to make, a little bit of a technical point, but a good one. If you can establish res ipsa loquitur, that does not reverse the burden of proof. Unlike section 62 of the evidence ordinance, in which the burden of proof is reversed and put on the defendant, okay, the burden of proof remains with the plaintiff, and it is possible for there to be evidence to prove that there is no liability. And the leading case on this is a case of and Lee. And Lee I can't see that in the course manual either, but in this particular case, it was somebody, I think it was a truck driver driving along the road, and lo and behold, he found somebody's coming straight at him head on. So the other vehicle was on the wrong side of the road, so the driver tried to take evasive action, and there was a crash. And the defendant, so the thing speaks for itself, right? So the plaintiff tried to rely on res ipsa loquitur. Was the vehicle under the management of the defendant, and the accident such that in the ordinary course of things does not happen if the defendant uses proper care? But that driver involved was able to prove that he took reasonable action when he was cut off. Okay, so he was able to prove that he had acted reasonably, and that's what I've got on the next PowerPoint. Okay, so the burden of proof with regard to res ipsa loquitur does remain with the plaintiff if res ipsa loquitur is raised. Okay, and the defendant may be able to produce evidence to prove otherwise, that he took reasonable action when he was cut off by the other vehicle. And there's another case, KMB and Chung, in which the defendant's response to being cut off, the court found, was not reasonable. Okay, so quickly just recapping then, the aids in proving breach. And breach of the duty of care is usually a big issue in traffic accident cases. Remember, the standard is that of a competent and experienced driver, but the plaintiff has to prove that the defendant is in breach. Section 62 of the evidence ordinance is a big help because it allows the plaintiff to bring in evidence of any relevant criminal offence, and the legal burden shifts to the defendant. Res ipsa loquitur is also useful, not quite as useful because the burden of proof still remains on the plaintiff, but it's still pretty useful evidence. If the thing under the management of the defendant was under the management of the defendant and the accident was such as in the ordinary course of things would not happen if the defendant uses proper care. So the Scott case is that. But remember, with res ipsa loquitur, not quite as powerful as section 62 of the evidence ordinance because the burden of proof still remains with the plaintiff. And so it may well be the defendant is able to show that he acted reasonably, therefore not in breach. So that's and Lee. I would say and Lee is a must-know case because it's an example of how res ipsa loquitur applies and unfortunately did not assist the plaintiff because the burden of proof remains with the plaintiff. Okay, all right, so that's pretty well it, everybody, with regard to breach of the duty of care. So what we shall do next time we meet is we shall review breach of the duty of care, and then we're going to get on to the next element of negligence, which have I got it at the top? The next element of negligence is going to be causation. Okay, so there you are. We've covered duty of care, everybody. And remember, the important thing with duty of care is be aware of what the damage suffered by the plaintiff is, okay? And if it's directly caused personal injury or property damage, it's simply Donoghue and Stevenson, duty of care, reasonable foreseeability. If it's nervous shock or pure economic loss, then you have to go further. So if the loss suffered by the plaintiff is nervous shock if the damage suffered by the plaintiff is nervous shock or pure economic loss, then you do need to go into further analysis. So duty of care is a bigger issue if the damage suffered by the plaintiff is nervous shock or pure economic loss, because you might have to the plaintiff would have to prove that extra element of proximity. Okay, so we've then covered tonight breach of the duty. Okay, Glasgow and Viewer must know, but don't forget Nettleship and Western when it comes to car drivers. And then with regard to proving breach, section 62 evidence ordinance, very good for the plaintiff, plus res ipsa loquitur. Okay, so they are really the must-know cases. And statutory laws, section 62 evidence ordinance. when it comes to breach. And I think wishing long hong's a good one too, because the facts are easy to understand. The standard of care of a reasonable employer, okay, in the circumstances, a reasonable employer would have provided more watches or torches for the employees in those circumstances. Okay, so there you are. We'll get on to causation then next time we meet. So causation we will cover next Tuesday as well. So we'll review breach next Tuesday, and then we'll get on to causation, and we'll just about finish off negligence next time with regard to proving the elements of negligence, but then we're going to get onto the defences to negligence. Okay, so the defences to negligence are in chapter 5, so you might want to read ahead. And the most important defence to negligence is going to be contributory negligence. Must know the law on contributory negligence. We've already mentioned contributory negligence in passing a couple of times. Okay, everybody, so that's it for tonight. Thank you for your attention again, and stay safe, keep the masks on, keep the social distancing and the clean hands. And we shall continue on with negligence next time. We do causation and then perhaps get on to defences to negligence. So you know our program, so you can read ahead and prepare yourself if you can, and we will cover that next time. Okay, thank you very much. Have a good evening, and I'll catch up with you next Tuesday.